Hi, I'm Carl Pearson, and this is a video where if you listen to it, you probably will be able to save your home or make some money out of litigation you happen to be in, because I'm going to give you some things that really aren't well known, but should be known by people who are in litigation. My name is Carl Pearson, and this is how you lost your constitutional right to a civil jury trial. Long before I started classes at Harvard Law School, I was aware that there is a constitutional right to a trial by jury in civil cases. I wasn't taught that this right no longer exists. If you can expect to become a party in a civil lawsuit, you will benefit from what I have to say in this video. Let's look first at criminal cases. The 1776 Declaration of Independence accused King George III of depriving citizens of their right to a jury trial. This problem was addressed in Article 3 of the United States Constitution by a provision that all trials were to be conducted before a jury. The Sixth Amendment to the Constitution added more protections, stating, quote, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed." Unquote. If the criminal defendant has not pleaded guilty and so wishes, that he or she is given a trial by jury, no matter how strong the evidence is for conviction, even if the defendant has admitted his or her guilt along the way, provided, of course, as I said, that he or she has not pleaded guilty. The purpose of these constitutional provisions was to provide a valuable safeguard against the corrupt or overzealous prosecutor and against the compliant, biased, or eccentric judge. Now, let's look at the right to a criminal jury trial in the 50 states. The U.S. Supreme Court has held that states under Article 3 and the Sixth Amendment are required to have a criminal trial by jury only if the possible sentence is at least 6 months in jail. I feel like President Trump at this moment. In New York State, a jury is available for felonies and Class A misdemeanors, and this is supplemented outside of New York City by Class B misdemeanors. In California, there is a right to a jury trial for all felonies and misdemeanors, and in Illinois, for example, all criminal defendants have a right to a trial by jury, which is another way of arriving at the same result, different language as in California. Now let's look at civil cases in the 50 states. This right to a jury trial in criminal cases is not the case as to civil trials, and in this video I will explain how and why. The Seventh Amendment to the U.S. Constitution guarantees a jury trial in civil cases. Every state has a constitutional right to a jury trial in civil cases, but do have limitations within state constitutional law, usually relating to a minimum dollar amount and whether there are equitable claims or defenses, which 200 years ago were decided by the judge. In spite of these constitutional protections of the right to a jury trial in civil cases, federal and state judges have developed two major ways to deny a jury trial in something like 95 to 98% of the civil cases filed that qualified for a jury trial. I'm estimating those percentages. There is no source that I can cite. More than 100 million cases are filed each year in state trial courts, while roughly 400,000 cases are filed yearly in federal trial courts. There are approximately 30,000 state judges compared to only 1,700 federal judges. When I divide 100 million by 30,000, I arrive at 3,333 cases per state judge. When dividing 400,000 by 1,700, I arrive at 235 cases per federal judge. I do, however, provide my source for these statistics in the description for this video, in case you're interested in whether my figures are supportable. If the average jury trial takes 3 days and a judge has an average of 1 trial per week, or 50 jury trials per year, the 30,000 state judges could have a maximum of 1,500,000 jury trials per year, but this is only 1.5% of the 100 million cases filed each year in the state courts, or if you take 1,700 times 50, that's 85,000 maximum, or 21% of the 400,000 cases filed each year in the federal courts. The actual number of state and federal civil jury trials is substantially fewer, and I'll assume 50% is the most possibly that could take place, because the judges have other duties to perform, so that less than 1% of the state civil cases and about 10% of the federal civil cases are tried, and probably 50% of them are non-jury trials also. So attorneys who recognize the probability of having no trial at all are more apt to encourage settlement for much less than what would have been obtained statistically if the case were allowed to be tried. That's something to remember now. So how does such a massive number of civil cases wind up with 0.3% getting a jury trial in state courts and about 5% getting a jury trial in federal courts, which my own experience indicates to me is too high a percentage as to the federal courts? There are 2 ways. First is the motion to dismiss the complaint. A motion to dismiss is usually made by a defendant to raise issues about the legal sufficiency of the complaint or to raise some defenses that prevent the lawsuit from succeeding, such as the statute of limitations or the lack of personal jurisdiction over the moving defendant. The judge decides a defendant's motion to dismiss, which often is for failure to state a claim upon which any relief may be granted. Each claim for relief is required by judges to allege what the courts have held are the elements of the claim, such as in cases of fraud, with 6 or so elements. These elements as to fraud are: 1. A representation of fact made to the plaintiff. 2. The fact was material to the plaintiff. 3. The defendant had knowledge of the falsity of the representation. 4. Defendant had an intent to induce plaintiff's reliance on the representation. 5. The plaintiff relied or relied reasonably in some jurisdictions on the representation. And 6. The plaintiff was injured as a result of the reliance. A huge expense in legal time is spent by both sides in the preparation of the motion to dismiss, including an often lengthy memorandum of law to argue to the judge, who, by the way, already has too many cases to handle properly, that the case should be dismissed because of the argued failure of the plaintiff's lawyer to allege each of the 6 fraud elements properly, followed by a costly plaintiff's opposing memorandum of law arguing that each of the 6 elements was in fact properly alleged, followed by a reply memorandum of law in further support of the motion to dismiss, arguing that the plaintiff's arguments were specious and should be disregarded by the judge. The overworked judge then has to decide the motion, and more often than not, and I have no statistics on this other than my experience, the judge will dismiss the action, usually with permission to file an amended complaint. After the amended complaint is filed, another motion to dismiss is probably going to be made, opposed, and all too often granted by the judge, who knows that he or she is overworked and doesn't have the time to give a jury trial or a non-jury, that's called also a bench trial, to every case that is assigned to him or her. What we have is a judicial system unable to provide the rights granted in the federal and state constitutions, and use of a motion to dismiss to get rid of the case and extinguish the claims of the plaintiff. The second motion is one for summary judgment, and that's really what this is about. Assuming the action survives the motion or motions to dismiss, there is a period of costly discovery, including very costly examinations before trial, also called EBTs or depositions, where each side tries to obtain evidence to prove its side of the dispute and disprove the opposing side, followed by a motion for summary judgment by the bank in foreclosure actions or by the defendant in many other actions. It is this motion for summary judgment that the judge has the authority, as a result, to deprive the losing side of a jury trial, or any trial for that matter. The summary judgment requires the judge to analyze the evidence submitted by the parties in affidavits and exhibits, with arguments in memoranda of law, and decide whether there is in fact any material issue of fact to be tried. The judge is supposed to read sometimes hundreds or sometimes 1,000 pages of affidavits and exhibits and make a determination whether any material fact does exist, and if so, identify the material fact or facts and deny the motion. However, the motion is, in my opinion, all too often granted dismissing the case. I believe that many of these decisions granting summary judgment occur because the judge has too many cases and has to narrow down the number to a manageable number for trial, bearing in mind the judge may have, say, 500 cases during a year, but time to provide a jury trial for only 50 at the most, and probably only 25 because of everything else the judge is required to do. In foreclosure cases, there is rarely a trial, and grant of summary judgment of foreclosure and sale is the typical result. Also, you should know the judge has no authority in law to order the bank to give the homeowner mortgagor a loan modification so he or she can remain in the property and avoid foreclosure, sale, and eviction. In summary, increasing the number of laws and increasing the number of lawsuits, coupled with little or no increase in the number of courts, judges, and courtrooms, has resulted in the loss of the constitutionally protected right to a trial by jury in civil cases. At the same time, with an ever-increasing number of criminal cases, there is always, 100% of the time, a trial by jury for whatever defendant wants it, which is one more reason for the reduction of civil jury trials. Well, I've said what I wanted to say, and I'll be back soon with my next video. I hope that you have learned something from this, so when you are involved in litigation, you'll be more responsive to your attorney and these motions to dismiss and for summary judgment.